Hello, we're all familiar with the story Who Moved My Cheese by Dr. Spencer Johnson. The story is a parable about how we deal with change, and in particular, change that dramatically impacts the primary objective in our lives, our cheese. A primary lesson from the parable is that those who are vigilant in sniffing out and quickly adapting to change are in the end best served and best positioned. I will briefly discuss how the implementation of the America Invents Act is changing the best practices for protecting IP in the United States, and in particular, how the post-grant review proceedings change over to a first inventor to file system and the expanded scope of prior art created under the implementation of the AIA have reemphasized the importance of adopting and implementing tailored IP prosecution strategies. The implementation of the AIA has catalyzed a paradigm shift in how companies seek to obtain, leverage, and challenge intellectual property in the United States. In particular, the post-grant review proceedings created by the AIA have proven to be powerful weapons for invalidating patents, true game changers for both patent owners and patent challengers alike. The proceedings typically cost less than 1/10 that of district court litigation, require a lower burden of proof, and are completed within 1 year. The new proceedings have been more popular and effective in invalidating patents than initially expected and have resulted in the cancellation of most or all the challenge claims in close to 80% of the final decisions as of June 12, 2014. Implementation of the AIA has also changed the U.S. from a first to invent patent system to a first inventor to file system and has expanded the scope of prior art considered for patentability. The first inventor to file patent system places a premium on speed and efficiency in identifying and evaluating IP and in preparing and filing applications as early and as completely as possible. The collective impact of the first to file system, expanded prior art, and new review proceedings increase the importance of conducting preliminary patentability searches and in carefully crafting and executing strategies that take into account these changes in the United States. The success rate of the new post-grant proceedings in invalidating patents has shined a spotlight on the importance of patent quality over patent quantity. In response, companies are adopting value-added strategic approaches in which inventors, IP counsel, and executive decision makers work closely to create and implement tailored strategies for assessing patentability, preparing and prosecuting patent applications, enforcing and leveraging IP rights, and challenging the patents of others. Companies are retaining experienced IP counsel adept in navigating the interplay between patent prosecution and the evolving nuances of the new proceedings. Companies are also shifting focus and resources from district court litigation to the new patent office proceedings. There's no denying that the seismic changes brought about by recent legislation and case law have eroded the rights of patent owners in the United States and have made obtaining a patent with a strong enforcement value more challenging. It's also clear that the current success rate of the new proceedings, if unabated, will have negative impact upon technology sectors such as the biotech industry, which rely heavily on patent rights as crucial value drivers for attracting, funding, partnering, and protecting discoveries. The changes brought about by the implementation of the AIA are here to stay and need to be considered in strategies for protecting, securing, defending, and challenging the IP rights of others in the United States. Additionally, these strategies need to be regularly reassessed and are likely to change and evolve significantly over the next several years as emerging case law and precedent establish and clarify the procedures and nuances of these newly established proceedings. As in the parable, Who Moved My Cheese?, those who are vigilant in sniffing out and quickly adapting to the evolving changes in patent practice will be best positioned to achieve their IP-based business objectives in the United States. For more information relating to how the implementation of the AIA has impacted your strategies for protecting and leveraging IP in the United States and the strategies being applied by your competition in response to the AIA, please visit the firm's website at www.skgf.com. Thank you.